Matthew, and which is file number 255454, and People versus Baumgart, which is file number 25545. Have counsel put your appearances on.
Sorry, Sierra Coke on behalf of the people.
James Dick on behalf of defendant Matthew, Your Honor.
Walter White on behalf of Lawrence Baumgart.
Your Honor, as a preliminary matter, I'd like to make a motion.
Okay.
Your Honor, I'd like to make a motion for me to consider here the motion that was.
Wait, can you say that again? I didn't hear.
Oral motion for leave to file the instant motion. This motion was actually filed one day late. I want to bring that to the court's attention. I'm sure it's already aware.
The motion to quash?
Yes.
Okay.
I miscalculated the dates. It was my professional error, and I just want the court to be aware of that. However, with that, Your Honor, I would ask that the court looks at the overall circumstances, that whether like prejudice is the people here. With that one day late, it was approximately 24 hours. It wasn't a week late, or it wasn't the day before the motion hearing. It would be better to hear the argument from the marriage rather than just a default in this matter. Ms. Cope was also had also already prepared the motion for essentially the same argument for the co-defendant's motion to quash the matter. And with that, Your Honor, the court does have the discretion to accept four rules of 2.41. And I would ask the court if you would do that.
Ms. Coke.
Your Honor, let's just proceed with the motion. So I filed the response.
All right, so the court will excuse the late filing issue, and we'll proceed today on both motions on the merits. So both parties have filed motions to quash. I did have an opportunity to review both the written motions, the transcript from the preliminary examination, Ms. Coke, your responses. And so, Mr. White, I believe you're supposed to file first. Is there anything you want to state by way of oral argument here today?
Again, Your Honor.
Anything you wanted to state by way of oral argument here in support of your motion today?
Yes, briefly, Your Honor.
Okay.
Yeah, I'm like usually when a lawyer says briefly, I'm not lying. On page 843. No. Obviously, Your Honor, we've got a situation where the charge is assault with a dangerous weapon against my client. There's also a misdemeanor charge that runs along with it that we're not addressing today. The standard for quashing an information is abuse of the discretion on the magistrate. We are limited to the four walls of the transcript in order to argue our motion. And I would, pardon me, I believe that I presented our position fairly thoroughly in terms of what my client is accused of having done, and the fact that the behavior of my client has does not fall within the definitions or the jury instructions of assault with a dangerous weapon. And it's our position that the abuse of discretion was because the bind over did not reflect the requirements of assault with a dangerous weapon, though I'm not saying it didn't reflect possibly some other crime, maybe a destruction of property, but we've got a specific intent crime here. We've got behavior that my client is alleged to have struck the outside of a tow truck with a stick, and that is a limited behavior. I don't think it rises to the level of an intentional assault with a dangerous weapon. And I would just ask Your Honor to refer to the transcript as you said you have, and take a look at also the statute and standard jury instructions for what a dangerous weapon is and what is required to convict of this crime. Thank you.
Thank you. Mr. Dick? Any argument? Yeah.
Yes, Your Honor. Just to caveat here, the required apprehension is an immediate battery, not just a generalized fear. Here, Mr. Ennis's person, he was inside the vehicle. The vehicle was not damaged in any manner. The vehicle was not something closely connected to him in this standard sense, whereas like something in somebody's hand or clothing would be impacted or closely connected to that person. And if, for instance, somebody grabbed somebody by the shirt, they could grab them and throw them down or yank them, or jerk them, or perhaps strike them. Here, this is a vehicle that he's in the closed cabin that's structurally sound. Mr. Ennis did say multiple times during the preliminary exam that his window was up and whatnot. There was one single strike to some area of the vehicle with the quoting tire thumper and allegedly a mirror touch. However, Mr. Ennis did say on page 10 of the preliminary exam transcript, line 21 to 22, he said he didn't recall if it was him or his truck hit his driver's side. That being said, Your Honor, of course, as the court's well aware, the truck, if used in a weapon-like manner, could be absolutely construed as a weapon. Here, the argument is that it was more generalized blocking and trying to stop the vehicle, where it was more likely characterized and should have been characterized as like careless and negligent, whereas ultimately something could have potentially happened. However, again, just to readdress Mr. White's point of the required intent, the preliminary exam, while the burden is extremely low, it requires some condition of intent to satisfy that. We would argue that it's not present at the preliminary examination. Washington.
Ms. Cope?
Your Honor, it's hard for me to understand how we can be sitting here today, even hearing arguments that this behavior wasn't intentional or it was not, does not meet the elements of specific intent. Not only did both of the defendants be present during the hitting of the vehicle with the large object that was either a stick or a bat, but they also both at different times during this cat and mouse game that they played with this guy who was just trying to do his job. They don't know him at all. They try to hit him with their cars, which in itself is a felonious assault. One of them actually did strike him with a car, and one of them he thought was going to hit him head on. There was multiple different assaults during this period of time, and how these men could act in this fashion and then say it's not specific is kind of absurd to me. They're standing next to each other, making him stop his vehicle while coming at him with a weapon, and then even after that, still continuing to chase him with their car, to the point that the police had to get involved and stop this chase. So this is clearly felonious assault. I think the jury trial will be very cut and dry, although I never want to say that about a jury, but the facts are very simple. And I think specific intent is so clearly shown that this motion is frivolous. Thank you.
Great. Again, I did review the transcripts. So I'm familiar with the testimony that was heard. I was not provided with the video as part of the motion, so I didn't review the video, but it's clear from the transcript that the district court judge did do that as part of the preliminary. So first of all, just looking at the standard here, the district judge is making the bind over decision based on probable cause that is probable cause to believe that the crime charge occurred, and each of the defendants were the ones who committed those crimes. And that's a very low standard, as the attorneys are aware. My review of that decision is even more deferential. The court's review is an abuse of discretion standard. And so in order to quash the bind over in either case, the court would have to find that the district court judge's decision was outside the range of reasonable principled outcomes. The law recognizes that in any decision by a court that there may be any number of decisions which are correct under any given set of facts. And as long as the district judge's decision is within the range of reasonable and principled outcomes, then I'm not to substitute my own judgment. It's not to conduct a de novo review of the facts. Again, my review is simply of the district court's decisions. In this case, having reviewed the transcript, it's clear that, number one, the district court based the bind over decision on evidence and testimony pointed to the specific portions of testimony and video that he felt justified probable cause. So it's clear to me that the district judge's bind over decision wasn't arbitrary or capricious, that it flowed from the actual evidence that was heard in the case. And again, I'm not to conduct a de novo review, but having looked at the evidence, number one, I think it's clear that the district judge didn't look at this in a vacuum. Somebody standing there holding a bat or a slab of wood or a thumper, I think it was referred to, tire thumper, in and of itself may not be threatening or assaultive. Contact between two vehicles in and of itself may not be assaultive, but you have to look at the context and overall circumstances. You've got a gentleman here who's repossessing a car, who encounters one individual and then another individual who are, from the perspective of Mr. Ennis, clearly upset and angry that he's repossessing the vehicle. Clearly engaged in a course of conduct to try and thwart that, to stop Mr. Ennis from driving away multiple times over, I think he said a 10 or 15 mile or minute, I can't remember if it's mile or minute, but over an appreciable amount of time engaging in conduct, which I think any person would find threatening, certainly a reasonable person who's repossessing a vehicle encounters two individuals acting the way these individuals were acting would be reasonably fearful. And then when those individuals take those actions to the other level, not just trying to get in the way of the vehicle, but actively trying to stop them approaching the vehicle with an object, which, again, the description, I think a reasonable person would be fearful or apprehend a serious battery from an object like that. Certainly striking of the vehicle, again, not in a vacuum, but under these circumstances as they were being presented to Mr. Ennis, he and any other reasonable person under those circumstances would apprehend a serious battery, and certainly a vehicle is a deadly weapon. I think the way that the wooden thumper or bat was described would arguably meet the definition of a dangerous weapon. And so for those reasons, I certainly can't find that the district court's finding probable cause as to both defendants in this case is outside the range of reasonable and principled outcomes. So the court finds that the motions to quash should both be denied on that basis. And I'll just ask both defense attorneys to prepare orders reflecting the ruling of the court, either with a stipulation as to form from Ms. Koch or under the 7-day rule.
I did provide blank orders in both of them in my responses.
You did? Okay,
Yep.
then I don't need the defense. Thank you. And then that takes us to the other matters we have set. Final status conferences. This case is set to go to trial next week, February 11th. I believe we have it set for 2 days. Is that correct? 2-day jury trial. So today would be the plea cutoff. Mr. White, have you had a chance to discuss with your client the plea cutoff?
we have discussed, and I haven't, we had an offer from the people and we don't feel we can take it. I mean, without going into the details of it, there's a medical reason why we can't take it. It doesn't relate to the reckless driving. I'll just tell you, my client is in treatment for cancer. The hard 2 months suspension of his driving privileges would be something he couldn't do because he's got to go to medical appointments all over. So,
Okay, so he's
So-
not gonna accept the plea offer.
no, we can't accept anything that didn't have that kind of driver's license consequences. May I ask the court a question?
Sure.
I have not tried a case in your county. Do you conduct voir dire or do you allow the attorneys to conduct voir dire?
I conduct some basic voir dire, but I do allow the attorneys to conduct some voir dire as well. I will say, I don't know, Mr. Dick, I haven't tried a case here yet.
Not before you go there.
Ms. Coke certainly has, she can, I'm sure, testify to the fact that I do and will limit attorney voir dire if I feel counsel's trying to try their case in voir dire. In my view, the purpose of voir dire is to find out if there is any basis for a challenge to the cause and to allow counsel to get enough information to reasonably exercise their peremptories. To the extent it goes outside of those bounds, attorneys frequently, in my view, do try their case in front of the entire veneer. I certainly will stop that. So outside of that, I do allow some voir dire.
Do you require proposed jury instructions or for your questions by a certain date?
Yeah, so we did send out a pretrial order which spells that out, but I can tell you typically, I think
I think ours are done, but I don't know if we went ahead and filed them. I plan to have them done by today.
So I asked all counsel to provide the jury instructions electronically in Word format so that I can edit them, throughout the trial and prepare the final instructions. I don't need defense counsel to submit full text instructions. I just need you to submit any objections you have to the prosecutor's proposed instructions or any different or additional instructions that you are requesting. So I get usually I get all the basic ones from the prosecutor, and I just need defense counsel to just add things you want that aren't in there, or if you had specific objections.
Or present those electronically?
Yes. In Word format.
I did file a full text version.
And that's fine. Yeah, but if you can also send my office. Okay, so we'll plan on Mr. Baumgart is not going to accept the plea agreement. Mr. Dick, how about your client?
It was my understanding that his plea offer was revoked already, so we will still proceeding to trial.
Is that correct, Ms. Coe?
The offer stayed open until today, I think. Sorry if my notes are wrong. Maybe I said that, but I didn't write it down. Offer to Mr. Matthew was felonious assault dismissed habitual third. Offer to Mr. Baumgartner was assault and battery and reckless driving.
May I take two minutes to discuss that?
I have a procedural question. Are we going to have one jury?
Well, we'll address that.
Okay,
Yes. I would do that.
thank you.
So